Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. I'm looking at a fascinating book today from Oxford University Press. And it's a modern book too, because a couple of years ago I'd have been talking about this and people would not have had any idea what I was talking about. But the title of the book is The Liability of Internet Intermediaries. Been written by Janny Riordan. Let's get his name right. Now, the book comes to us from OUP, and it's very much in the house style. We'll look at the book in a minute. But I think it's a great contribution to where we are at the moment with the new technology and what is happening in the second decade of the 21st century, and the changes that are just about to start with the fourth industrial revolution, because we're into a very new era very quickly. Things are moving ahead very rapidly as I record this in the autumn of 2016. Now, Elizabeth and I have given the title of our book review for this work, The Legal Landscape of the Internet, Practicalities and Pitfalls, an important new work of reference from Oxford University Press. Here it is, red cover. It's the book, first edition book. There is the spine, there's nothing on the back. And the book is heavy. It's a paperback. It's not a paperback. It's a hardback. And here's the index at the back. It's by paragraph numbering. 600 odd pages long, the book itself. And Janny has produced, I think, a very good book here. A huge amount of work has gone into it. Just looking at the index itself, you can see the sort of subject areas covered. You can see also, even from the back page, paragraph numbering at the side, lots of footnotes. If we go to the front, you can see here at the front, there's the front page itself, and then from that you've got a very useful foreword from Lenny Hoffman. Very important person, of course, Sir Leonard Hoffman, or Lord Hoffman as he now is. It was written in April 2016, and he refers to his friend, the late Professor Dworkin. So you've got a lot of information from Hoffman, who is an absolute international treasure as a lawyer and jurist, and he sets the picture well. He says it's impossible to understand the law of internet liability without understanding how the internet works, and that, of course, is why I said right at the beginning that a few years ago you wouldn't know what I was talking about. But the internet has changed our lives, and that's the fourth industrial revolution we are now at the beginning of. There is the preface, and this is the sort of thing we're going to be looking at in the future. The preface is a relatively short one, and then we get into an overview of the subject, and then you can see the various parts as the book develops. Quite a detailed actual index or content section at the beginning. Remedies and limitations right at the end, as to be usual. Website blocking in Europe, interesting area. And then chapter 17 and 18, miscellaneous and costs issues right at the end. Then the index at the back. ADR is covered right at the end, alternative dispute resolutions. And then you've got the list of cases. So it is an international book, this, of course. It's got to be because of the internet. Tables of cases by country. A large number of them. Then tables of legislation, again by statutes by country again, and then codes of practice. And you've got treaties and European legislation. The effect of Brexit again could have quite a pronounced change possibly in this book in the years to come, but at least we have it at the moment. Very useful abbreviations, because we do with anything international there are lots of abbreviations. And some of them, no idea sometimes because one forgets what some of them are actually. When you look at the abbreviation, you think you know what it is. This is actually quite helpful because you can pinpoint immediately what it's about. Now, the structure of the book, you've got a nice little index per chapter at the beginning. I like that house style very much myself. There is the paragraph numbering at the side, and then you've got, as you can see, lots of lovely footnotes all the way through. Internet intermediaries are essential features of modern commercial, social and political life and the dissemination of ideas. That's the start of it. And then it goes into, for instance here, contempt of court. What a big issue. jury deliberations, the biggest single problem for some cases. They're looking at the defendant, then they go home and Google his name, and they're not allowed to, but they do, and you see what the problems are. This is the liability of internet intermediaries. Now, what do we say about the book? It's a new book. It's a new area, and as I say, it's a fascinatingly thoughtful area as well, because we frankly don't know what we're doing. It's a huge jump into the dark with the internet, and the implications. Of course, people are bound to be wary about it, but the question then is, what are the issues of liability? So this is what we say about what Gianni Riordan has written. I think it's a first-class work, and something anybody interested in internet and law will find a particularly attractive work to read. Has some nasty internet troll been saying mean things about you on Twitter? Has somebody else stolen your intellectual property? A book or a film or a new tune or a new trademarked hairdryer, and marketed it online. Now, these are just some of these very modern areas that we need to talk about. Or if all or some of this concerns you, or perhaps your clients, be advised that hand-wringing and gnashing of teeth will not suffice. What you need, at least in the first instance, especially if you are a practitioner, is this new work of reference, very innovative in my view, just published by OUP. And references it has aplenty, with almost innumerable cases cited throughout. And the author, Gianni Riordan, I hope I pronounced the name correctly, Riordan I should suspect it is, admits, quote, "There is no book dedicated to the doctrines and remedies which regulate the legal liability of internet intermediaries. Hence the need for this book, which covers this often abstruse subject with commendable clarity." And then internet intermediaries, as Leonard Hoffman explains in the foreword, are not the primary authors of internet torts. Rather, they are, or maybe in his words, the ISPs, platforms and other intermediaries through which they act, which are often visible and substantial. Now, I would say one thing, as a practicing barrister here in the practical area, we know where they are, we know who they are. Well, let's deal with it, because that's one of the problems in terms of enforcement and trying to find these people. They are actually quite visible and substantial. We know where they are. Other examples of internet intermediaries, as enumerated by the author, include website operators, data centers, app suppliers, social networks, search engines, and more. The gatekeepers of the world's knowledge, he calls them, many of them household names. Given the importance of internet intermediaries, Riordan also points out that their liability is of considerable interest to a society that values the continued freedom and utility of the internet. Now, again, that's an important point, because there are going to be some people who don't like the internet. Some countries try to control it, but it's a great device. It's a wonderful device for the 21st century, and it gives you continued freedom, and it's a utility. One of the points about freedom is anybody who's a dictator doesn't like this sort of thing, because it's going to give you information, and that's one of the things that basically you cannot control, because you can get information on all sorts of things which hitherto would have been much more difficult to access quickly. Now, the prime issue that emerges here is therefore that of secondary liability. That is liability for the torts of others, a previously somewhat obscure area of law, says Hoffman. With the proliferation and widespread use of the internet, however, it's unlikely to remain obscure for much longer in our opinion. And the publication of this authoritative legal text, and other ones like it, will obviously serve to bring this highly complex subject that much further into the light. And of course it is, if you like, a development of the law of tort. It's bound to be, it's tortious liability. I mean, it's a bit like IP, intellectual property. It's the same thing. It developed from tort. Obviously the contract law comes into it, but it is fundamentally, I think, when you're looking at substantive law areas, it is that particular area you'll be looking at. The book originated from the author's doctoral thesis, is a sort of research on secondary liability, which he undertook at the Faculty of Law at the University of Oxford. Then subsequently was supported by the Clarendon Scholarship Fund and the Oxford Australia Scholarship Trust and Magdalen College, Oxford. Thank you, Magdalen College, Oxford, very much. The subsequent augmented and updated research that he covers, we would say, involves every conceivable aspect of this proliferating subject area, and it is growing, it's changing, it's going to change again. We're in the fourth industrial revolution, we've just entered it. There are going to be massive changes up to 2020 and beyond, and they're going to happen quite quickly. And of course it touches on the many areas of concern that we now have, from identifying the defendant to intellectual property issues and data protection issues to remedies, including blocking, big area right at the back of the book, which again is very feeble attempts by some countries. You can understand why, because of the threat of dictatorship, the oppression, all sorts of other things, but there is the blocking mechanism. And of course costs are involved and much more besides. It's an important area. Now the detailed 7-page table of contents, and detailed index plus numbered paragraphs throughout make the book reassuringly navigable. I found it quite easy to read, actually. I mean, one of the problems is there are quite a lot of paragraph numbers quite close together, but you can find what you're looking for pretty quickly, especially if you are in tune with what I would describe as internet terminology, because some people really do find it a difficult and very, actually quite awesome area to be involved in. So put that to one side, and then you find with a more relaxed approach you should be able to pick up what they're saying pretty quickly. The footnoting, of course, is extensive, and there are almost 30 pages of tables of cases, of legislation and treaties under the European legislation. For how long, I don't know. Brexit people, beware. Let me conclude by saying, as the internet is now all-pervasive, with a power and an influence that is almost unimaginable in scope, this erudite and comprehensive analysis of the liability of its intermediaries should ideally be acquired, we think, by every practitioner, especially international lawyers and IP specialists, as well, of course, as legal researchers and academics concerned with this fast-changing and dynamic area of law. I also think it might be interesting for businesses, and it's got a wider readership potential too, even though it's effectively a mainstream law book. The publication date is cited as April 2016. I'm delighted with this book, as you probably gather. There it is again. You've got some heavyweights involved in it too. There's the front. Let me just remind you again, that's the big heavyweight, Leonard Hoffman. Very important contribution he's made. I was introduced to a computerized word processor by Professor Dworkin, a large tin box made by IBM in about 1980. Well, unfortunately, I go back a bit earlier than that too, because I go back to 1974 and IBM. But however, that's another story entirely. The preface is first class, and the book itself, Causes of Action Against Intermediaries. As I said, it is tort-based fundamentally, but jurisprudence comes into this, and the future comes into this, because that's what this is all about, identifying a defendant. It's all the questions that need to be asked, because this is the beginning of a brand new area of practice, probably for a lot of people. Graduated response obligations. See, the structure's very clear. You've got paragraph numbering and you've got footnotes and so forth. Altogether, a lovely book. Janny Reardon, thank you very much indeed for it. I'd like to thank everybody involved at OUP for producing it, and I expect there will be further editions of this in a not too distant future. Thank you to all concerned. Do look at our review on the web and in the journals. Bye-bye.